Silence, court rise. Part heard appeal in Page and the NHS Trust Development Authority.
Yes, Mr. Riddle, just before you start, I think I said yesterday that we didn't have the petition and Bishop Nazarali's statement that were referred to in the Employment Tribunal decision. Although Mr. Dowman didn't correct me on that, I've checked for myself, we do have them, but the perversity difficulty in the context of which I made those points to him does remain, because what we don't have is any note of the oral evidence. But I thought I ought to put that clear, make that clear. Yeah.
And whilst we're also dealing with tidying up from yesterday, if I can put it
Yes.
that way, we had an issue yesterday, my lord, about the correctness of who had been the respondents.
Yes. What's the answer on that?
And it would appear that there is a slip in the tribunal's decision at 11.9 that when they refer to the trust having been dismissed, that should be a reference to the Secretary of State.
Yes, so the trust has never been a party.
That, I believe, my lord, is right, and I have seen the case management order of the 7th of January 2017 dismissing the Secretary of State as a respondent to the claimant, confirming that the TDA, my client, is the correct respondent.
Oh, fine. Thank you very much.
Therefore, with those matters dealt with, my lord, the structure I'm proposing to adopt in my submissions this morning, first is to look at the direct discrimination claim,
Yes.
to address the court, first of all, on the Charter and Convention rights, to the extent that those are relevant, and then to look at the question of the reason why. Then secondly, to look at victimisation, and then thirdly, to deal with the indirect discrimination claim. So to start with the direct discrimination claim, I said the words "to the extent relevant" because, as we know, there is no challenge to the legislation as such. There is the well-known interpretative obligation to interpret legislation consistently with the Convention and indeed with Charter rights. But we know, of course, and the court have my submissions from yesterday, that the Equality Act does protect an individual from detrimental treatment because of religion, because of the manifestation of religion, where that is not treatment that would be afforded to others. I'll deal very briefly with the question of whether or not there is any material difference between the Charter and the Convention, because I say that there is not. They do exactly the same thing. And my lord and my lady, that point I will make good very briefly by reference to the Arbiter and G4S case, which you have in your authorities bundle at tab 40. It's a Court of Justice case concerning the wearing of a headscarf, or a desire to wear a headscarf by a Muslim employee in the workplace. But at forgive me, page 956 is part of the judgment of the court, and at paragraph 25, it is noted that religion, for the purposes of the directive, this is the framework directive, of course, doesn't have any definition of that term. But then it goes on to note at 26 that there is reference in the recital to the directive to fundamental rights as guaranteed by the European Convention for the Protection of Human Rights and Fundamental Freedoms, and there's a particular reference to Article 9. And then at paragraph 27, in the same recital, the EU legislature also referred to the constitutional traditions common to the member states. Among the rights resulting from those common traditions, dropping down, is the right, reaffirmed in the Charter of Fundamental Rights of the European Union, is the right to freedom of conscience and religion enshrined in Article 10 of the Charter. And then at 28, it says, insofar as the ECHR and subsequently the Charter use the term religion in a broad sense, the EU legislature must be considered to have intended to take the same approach when adopting the directive, and therefore the concept of religion in Article 1 should be interpreted as covering both the forum internum and the forum externum. So religion means the same thing, whether one is looking at the convention or whether one is looking at the Charter. I mention that simply because Mr. Diamond, in his skeleton argument, seems to draw a distinction between the two and to suggest that in some way the analysis under the Charter is broader and may yield a different answer to the analysis under the Convention.
Can I just ask one other thing, which I'm afraid is ignorance on my part, and may not be relevant to this case, but possibly is. I asked Mr. Diamond whether the Convention rights, and the same in reply to the Charter rights, would cover philosophical belief of the type covered by our legislation, where it was not rooted in religion of in any normal sense of the word. And he said yes, it would, because it's well established that the Charter covers. See what the phrase.
Thought and conscience.
Yes, thank you. Thought and conscience. Suppose it were the case that there were discrimination against Mr. Page, but not on the basis of his religion at all, but simply on the basis of expressing a view about a deeply held personal view about same-sex adoption.
Yes.
Would that be covered equally by the Charter and the Convention?
I suspect the analysis would be similar to the analysis of the EAT in Granger, where they analyse what a philosophical belief is, that every passing thought that one might have wouldn't qualify as freedom of conscience, but a deeply held belief system might. I hesitate to give an answer because I don't know what the court would make of it.
Well, no, but that was, I think, I haven't, sometimes since I've looked at it, that was purely a exposition of what the UK statutory language meant, which isn't, I don't think, that the actual language of freedom of thought and conscience is used. What I'm really just wanting to tease out is whether, in your submission, there's any difference between the concept of thought and conscience on the one hand and the UK language of philosophical belief as expounded in Granger.
My Lord,
I mean, on the whole, one would think not.
my Lord, I would be inclined to think not, but as to whether or not it's relevant to this appeal, I suspect it isn't, because the way that it was put before the tribunal and accepted by the tribunal was that there was a religion here in play, plainly Christianity, but also it was accepted that there was a philosophical belief within the definition of
religious
faith. Yeah, I think that the way that the tribunal puts it, my lady, might be philosophical belief. But if you just bear with me.
Yes, I, like you, I'm not sure that it matters in this case, but I haven't sufficiently bottomed out to myself whether it does or not. So I thought it was prudent to explore it with
Yes,
you.
of course.
Let's just have a look.
Yes, you're right. Paragraph 46, a philosophical belief. I'm sorry.
Thank you, my lady. But I suspect I suspect that the reason the tribunal deals with it in that way is because Mr. Pays chose to isolate a particular aspect of what he said was his religion and rely on that in addition to Christianity as a belief in its own right.
Yes, well, I think that's right. But it's easy to confuse it with the position in the other case, and I can't now immediately remember which is which. In one of the cases, or one would assume in both, though actually he was differently represented, so it might not be the case.
Yes.
He was putting his case both broadly in terms of religion and narrowly in terms of
Yes.
philosophical belief.
And and certainly that was this case.
Yes.
Both aspects were relied on, and that, my lord, is what leads me to give my answer to your lordship's question. That I think it doesn't matter for the purposes of this appeal whether one would define.
Well, I'll tell you why.
Article 19.
Again, this may be ill thought out, but let us suppose that. Yes, I see. Now, I'll follow the thought through, and then you can just so that we can see that it's wrong. I think it is. There could be circumstances in which he could only get home by giving a wide, by relying on the convention, not on the domestic legislation. You would say not, but I mean that's I think that's part of his case, or at any rate on using the convention to give a strained meaning to what would otherwise be the domestic law.
Yes.
But if it were the case that this was only a philosophical belief, then it would be important to know whether the convention protected the philosophical belief as well as a religious belief. Are you following me? I think I'm rather long-windedly coming to the point that you were making. Given there's a finding that this was a religious belief as well as a philosophical belief, it's hard to see how that problem could arise in this case.
Yes.
Sorry to take such a long time to get there.
No, not at all, my lord.
It's
But
helped me.
I do take your point. In a different case, it might rather matter, but not this one.
Yeah. Okay.
And the tribunal in our case concluded that Article 9 was not engaged in any event because they concluded that what Mr. Page had done in speaking to the media was not a manifestation of his religion or belief. And they deal at page 316, starting at paragraph 49, with the convention argument.
Just one moment.
Was your statement that they found that this was not a manifestation of belief?
My lord, yes.
Yes, could we just see where that
Yes,
sits?
of course. So they start at paragraph 49 with the convention analysis. And then at 52 over the page, they refer to Article 9.1 of the convention, giving absolute protection for the right to freedom of thought, conscience and religion. And then they go on at 53 to say that there is also protection for the right to manifest religion or beliefs, but they make the point correctly that that is a qualified right, and it is possible, of course, for that right to be interfered with in a way that is justified. And they say at paragraph 55 that here the act or acts resulting in the respondent taking action were not the claimant holding or expressing his views as such, but the claimant accepting invitations to appear and then appearing in the press and on national television, compounded by the fact that he did so without informing the trust when he had been expressly told to do so. Expressing his views in that context was not something that the tribunal finds was intimately linked to his religion or his beliefs. They say no sufficiently close and direct nexus between the act and the underlying belief. And that language comes directly from a wader. The court has a wader at tab 35 of the authorities bundle. When the wader had been dealt with domestically, there was a lot of attention paid to the question of did it matter that the manifestation of belief was particular to an individual or a small group, but might not be what might be described as a mainstream view within a particular religion, and therefore the court was asked to look at Article 9 and how Article 9 protects manifestation of religion. And they deal, and it's page 826 in the authorities bundle, with Article 9. And the court says this, even where the belief in question attains the...
So, sorry, which page are we on?
Forgive me, 826, paragraph 82, my lord.
Yes, thank you.
They say, even where the belief in question attains the required level of cogency and importance, it cannot be said that every act which is in some way inspired, motivated, or influenced by it constitutes a manifestation of the belief. Thus, for example, acts or omissions which do not directly express the belief, or which are only remotely connected to a precept of faith, fall outside the protection. And then there are some references, and then it says, in order to count as a manifestation within the meaning of Article 9, the act in question must be intimately linked to the religion or belief. An example would be an act of worship or devotion which forms part of the practice of a religion or belief in a generally recognised form. However, the manifestation of religion or belief is not limited to such acts. The existence of a sufficiently close and direct nexus between the act and the underlying belief must be determined on the facts of each case, and then goes on to say that you don't have to show that you're acting in fulfilment of a duty mandated by the religion, which I think might be the specific point that was in issue in a wader. And Mr. Diamond, in his submissions to this court, says essentially that the tribunal was obliged to find that what Mr. Page did was a manifestation of his belief. But with respect to him, his submissions slipped between Article 9 and Article 10, because he also said...
Hang on one second.
There seems... I'm so sorry.
No, after you.
There seems to be some confusion in some of the arguments advanced in the appellant's skeleton argument as to what the act is when there's a discussion about a close nexus between the act and the belief. It's not the act of the respondent, it's the act of the individual that the individual says is the manifestation.
Precisely so, my lady. Act means different things in different contexts, but when we're talking about the act here, I entirely agree with you, my lady, we are talking about the act of the individual. And that is where we, in my submission, get an eliding at times of Article 9 and Article 10, because it was also said by Mr. Diamond in his submissions on the Lord Chancellor's appeal particularly, but also in this appeal, that what Mr. Page was doing was speaking out. He was contributing to a debate, and that is the language of Article 10, and not the language of Article 9. And, of course...
Well, I see that, and we mustn't fall into the same trap. But speaking out about a matter of religious belief is a manifestation. It's clear it doesn't, although the paradigm may be religious worship.
Well,
Wouldn't saying the Bible takes this view, saying publicly the Bible takes this view about homosexual acts, and I adhere to that, wouldn't that be a manifestation of his religious belief?
well, my lord, I would say no, and the reason I say that is the decision of Ngole in this court,
Yes,
which you have at tab 25 of your authorities bundle. What had happened in Ngole
I'm sorry, because I know you were answering my lord's question. Are we going away from Awada?
Oh, but forgive me, my lord. Yes, we are.
Right.
And,
Well, can I ask you a question before
of
we leave
course, yes.
that authority? Because I just want to follow this through. We helpfully have Article 9 set out in the Tribunal's decision at para 39, so that we can just follow through exactly what is involved here. The operative parts of 9.1, I start from the third line, are freedom to manifest his religion or belief in worship, teaching, practice and observance.
yes.
Right. Now, that's been considered in Awada, and you've given us the reference, and the tribunal took it up at 54, sufficiently close and direct nexus
Yes.
between the act and the underlying belief. Now, one might ask why. This may or may not be a matter which comes up on the appeal, but I just want to get it clear in my mind. Why going on television and talking about your beliefs in relation to same-sex adoption is not manifesting your religion?
Well, and that, my lord, was the point I was hoping to answer by reference to the Ngole case.
Well, can you, without reference
Oh,
to
of
authority,
course.
just explain why it isn't?
My lord, yes. Because what is plain from Awada that everything that you say, which might be said to be motivated by your religion, it doesn't fall within manifestation of religion, because otherwise anything that you say is motivated by your
I understand that. Go to 82 in Awada, which is why I was stopping you leaving that page.
Of course.
I mean, this is really to do with the finding of the tribunal at 55, where they simply say there wasn't a sufficient nexus. But
Yes.
why wasn't there a sufficient nexus?
Well, there wasn't a sufficient nexus, I say, my lord, because what Mr. Page was doing was contributing. This is the language of the appeal itself, contributing to a debate.
Well, that's
It
just a
wasn't.
label. What you've got to face up to is that he says, in terms on television, I can't remember the exact quote, but effectively he says that the Bible, which is the root of my religion, says that homosexual sexual activity is a sin. And to be fair to him, he says not just any sexual activity outside marriage, but
Yes, I mean, yes, exactly so, because Mr. Page has been careful to say that it wasn't, it said that this wasn't specifically about homosexuality. It was about a view that sin outside marriage was a sin, but it is nevertheless an expression of view motivated. I'd accept that.
But Awada doesn't say anything that if it's motivated by religion, it isn't a manifestation.
No.
It merely says the fact that it is motivated isn't sufficient in itself.
Yes.
Of course it was motivated by his religion, but the next question is, and is there a sufficient nexus? And what I'm putting to you, and my Lord can speak for himself, but is, given what he actually said here, which involved a specific reference to the Bible and made it clear that the view he was expressing was rooted in his religious belief, why doesn't that create a sufficient nexus?
Because I say, and in a moment I will go to Ngole, because this point was grappled with by this court in Ngole, and they answered in much the way that I'm answering now, which is to say that a religiously motivated contribution to a debate doesn't go far enough in order to count as a manifestation of religion, because otherwise, of course, the Awada test would be satisfied in all cases.
But then you're into 9.2, and isn't that the better way around? That you're recognising it is a manifestation, but one isn't entitled to manifest one's belief anywhere, anytime, any place.
And my lady, I certainly do rely on 9.2.
Yes, but let's stick with 9.1 for the moment,
Yes.
because unless you're going to abandon your saying the tribunal's primary reasoning on this, the question is it even engaged, which means, is it a manifestation?
And that is where I say, no, it is not. And the reason it is not is because it doesn't go further than what I'm choosing for shorthand to call a religiously motivated contribution to
I don't know where this concept of... okay, you're going to show us Ngole in a minute. We won't stop you for much longer. But I want to deal with this at the level of principle.
Yes.
I don't see why a religiously motivated contribution to a debate may not be a manifestation. Suppose there's a television debate about whether or not gay marriage should be made lawful. And there is a Christian spokesman
Yes.
who says the Bible teaches that marriage can only be between a man and a woman.
Yes.
Well, that is a religiously motivated contribution to a debate, but it seems to me that there is a very close and direct nexus between what he is saying and his religious belief. Suppose it's a bishop saying it.
Yes. But my lord, I still think you come back to the religion as the motivation for the comment, but it doesn't make it a manifestation. And of course, one must remember the wording of 9.1, to which my Lord Justice Peter Jackson referred. There is freedom to manifest one's religion, but it says at Article 9.1, it's a freedom to manifest one's religion or belief in worship, teaching, practice, and observance. So going on television, one is already stepping away from
That may be your better point.
I think of a core 9.1. What is 9.1 intended to protect? It is what is said often in cases like this is, it's no good allowing me simply to be a Christian or be a Muslim or be a Jewish person, whatever the case may be. I have to be able to adhere to my faith, otherwise it is meaningless. And that, in my submission, is what 9.1 is then encompassing by talking about worship, teaching, practice, and observance.
Well, this argument, speaking for myself, I follow.
Yes.
But it doesn't seem to be the way that the tribunal dealt with it.
Well, my lord, the way that the tribunal deals with it is to regard.
Yes, but for example, you've placed emphasis, and I see why you do, on the concluding words.
Yes.
Of 9.1.
Yes. I suspect that the tribunal deals with it in the way that they do because they deal with it. They faithfully follow the guidance in Awada. But if one thinks about what the guidance in Awada is getting at, if I can put it in that way, it is about trying to draw some sort of line logically between everything that a religious person does is a manifestation belief, which is too wide, and Awada says that's wrong, and it being circumscribed too narrowly. So that it only becomes, for instance, being a Christian and going to church. It's got to be more than that. It's got to be, and an example, my lord, might be one of the authorities that you have in the bundle, which I was going to come to shortly, is a case called Wasteley, in which proselytising, there was an issue about whether proselytising might be said to fall within the ambit of Article 9. Now, the EAT in that case decides for different reasons that the appellant doesn't succeed, but that might be, for example, something that is said to have a close nexus to your religion. The fact
Well,
that
isn't it proselytising for a bishop to appear on the television? And, well, okay, it's not strictly speaking proselytising, but it's very close to it, to say that the law of the UK should conform to Christian teaching that that marriage should only be between a man and a woman.
And my lord, there may be cases which are difficult factual cases, because, for instance, one person might say, well, actually, I am appearing on television as part of my belief that I need to go out and spread the word of God. And therefore, one might say that in that context, that is a manifestation of belief, but that is not this case.
And indeed, Awada was exactly that situation.
Yeah.
Having not worn her cross visibly outside her uniform for however many years she'd been employed, she said, I wear my cross and I must wear it outside my uniform as part of my belief that one must display one's belief in that way.
And that was not, and I'm grateful, my lady, because that is not this case. Mr. Page never said, I went on television in order to spread the word of God. And in fact, he was at pains to say, I didn't court media interest. I responded because they wanted to ask me questions about my decisions in relation to the
But
magistrate.
it can't depend on whether you ask to go to telly or whether you agree to go on
No,
telly.
I don't mean to suggest that it's who does the asking, but it's what I mean to say, my lord, is when you're looking at what is being said and whether it's a manifestation of belief. If somebody is saying, I am going on television to express my views as part of spreading the word of God, that, taking up the example that my lord put to me about the bishop going on the TV debate, that might be said to be a manifestation of belief. But somebody simply answering questions and in the course of that contributing, albeit from a religious perspective, to a debate, I say that doesn't fall within the manifestation of belief, and the tribunal was right to conclude.
No, well, I quite see there are difficult choices to be made here, but and one can easily see. Well, let's take a debate which has a strong religious component, but which people also feel very strongly about without any religious component, namely abortion. You might well have a debate about abortion in which someone who was in fact a Christian argued on grounds that didn't involve any specific invocation of the Bible or of Christian teaching, that abortion was wrong, or that abortion at a certain date, after a certain date, was wrong. Now that, I take your point. But here, what Mr. Page said was very specifically rooted in his Christian belief. We're really talking about the Piers Morgan interview.
Yes.
And I ought to have every word of it fixed in my mind. But I'm right, aren't I, that he specifically invoked...
But he doesn't, well, I think it is,
Scripture.
I think, my lord, it's page 297 of the core
Yes.
bundle. And he is, it's the italicised part of 11.29. And he's asked the question twice by Piers Morgan as to whether he thinks being gay is unnatural. And the answer is, being homosexual in Scripture, it doesn't say that being homosexual is good or bad. So he doesn't actually rely on the Bible to support his view. In fact, he says that the Bible doesn't say anything one way or the other on the point. What is your belief? Asks Piers Morgan, what is wrong as homosexual activity? Really? Yes, a sex outside marriage is not right. And then he says that he doesn't agree with same-sex marriage, he doesn't agree with same-sex adoption, he doesn't see that ever be the best for the child, that is my responsibility. So he doesn't invoke the Bible in support of his position. He is answering questions about his personal views. So I
Seems
come
to be very fine distinctions are being drawn here, and sometimes to the advantage of people who want to go out and push their beliefs rather than people who simply want to express them.
Yes.
Should the law be making such distinctions?
Well, my lord, that might be a question that directed at the European Court in a way, when they do ask the domestic courts essentially to draw these fine distinctions between different cases.
Well,
Because otherwise, the simpler answer, the simpler answer might well be to say, my lord, is that if you are a religious person, when you say things motivated by your religion, then that's covered by Article 9.1. But that is not what a waiver
Well, I'm
says.
sure we'll let you get on to two in a minute, but I mean, the Awada message is the existence of sufficiently close and direct nexus
Yes.
between the act and the underlying belief. I mean, how can it really be said that the act going on television was not in a close nexus with the underlying belief?
Because going on television, in and of itself, has no nexus with one's belief at all. It's
oh, my lord, what he
no,
said.
no, no.
well,
But what I think my lord is putting to me is whether speaking on television has that sufficiently close and direct nexus with the underlying belief, so that it counts, if I can put it that way, as a manifestation.
Well, I
of
might put
belief.
it the other way and say that if it was accepted that saying it to 2 or 3 friends on the village green would be a manifestation of belief, why does it cease to become a manifestation of belief simply because one says it in a television studio?
I'm not sure, my lord, that I would accept that the 2 to 3 friends on the village green would be a manifestation of belief.
Well, where in that case could somebody in Mr. Page's position manifest this belief, this philosophical belief?
Well, if as I put it a moment ago, if it is said that the speaking out is part and parcel of, if I put it in that way, of the religious belief, then I can see that
Well,
might
is your
be
answer, in
manifestation.
fact, there's no way that he can do it because it simply isn't sufficiently, that the statement about same-sex adoption simply isn't,
Well,
doesn't have a nexus whether he says it in private or in public.
I think that is right, my lord. But of course, the context in which we're looking at the statement in this case is that it was the contribution to the debate on the television
But
programme.
that doesn't help us as to 9.1. The tribunal approached this in 55, is it, by starting off by referring to the television aspect of it and then going on to make the finding that expressing views in that context was not something was intimately linked.
Yes.
But testing that, because
Yes,
it's simply a bald conclusion stated by the tribunal without more,
Yes.
is there anywhere that he could have made this statement without falling foul of the same exclusion of Article 9 altogether?
It seems to me, my lord, if one looks at the statement that was made in this case, I think my answer to your lordship's question would be no. There was. It isn't, whether he could make the statement in one place or another. It's about the nature of what was being said.
Right. So the words "in that context," which appear 4 lines from the bottom of 55, are maybe contextual in this case, but they're not necessary.
Yes, I would agree with that, my lord. They're not necessary here, but what is said by the tribunal, I don't demur from, which is in the context in which Mr. Page was speaking. That was not a manifestation of belief. May I?
could I just,
Yeah.
we will let you come to Angola in a minute. I've been rather cautious before saying this. I think I'm right. We see at 11:29, we see the tribunal has seen and taken into account a transcript of the entire interview,
Yes.
and then they set out what they regard as one of the key passages. Key passages include,
Yes.
we, I don't think, do have the entire transcript, do we? Is there any reason why we shouldn't? I don't know why it hasn't been put in the bundle. If it was clear that the tribunal had only relied on this passage, then perhaps it would be inappropriate. But they make it clear that they're taking into account the whole thing.
I see your point, my lord. I have not seen the complete transcript either. But no, I don't see any reason why this
Speaking
court
for
should
myself,
not see the entire transcript.
and ask my lord and my lady, I think it would be appropriate we should see the whole transcript, and I'm hoping it can be got to. It may not be able to be got to us in the course of this hearing, but it must be in the archaeology of the case quite easily accessible. Whether it's physically in court at the moment, it's another matter.
Of course, it must be.
Mr. Diamond, do you have it in court?
I'd have to make inquiries on that. I don't know we have it with us.
Well, I think given the importance of this interview, I think we should see it.
Well,
I'm informed we could probably obtain it and print it out.
well, I'm rather surprised if one has to, in this day and age, look at it on a transcript. I mean, if we're looking at it, we might as well look at the clip, which presumably exists.
Speaking for myself, I respectfully agree, my lord, that it might be good to see that as well if it's available. But if what the tribunal saw was a transcript.
Yeah, that's just what I was inquiring, Mr. Diamond, because if the tribunal didn't view the footage, then
Yes, I understand.
I wouldn't think it's appropriate for this court to be.
I'd certainly, speaking for myself, it's the transcript I was asking about.
So we will. Well, I'm sure that between us we can make inquiries about.
Yeah, it certainly won't have to be transcribed. Obviously a transcript exists. It just isn't physically in our bundle. Yeah. Okay. Right. Do you want to take us to Angola, or do you want to say anything more before you do? We've been stopping you for the last 20 minutes, but.
No, not at all. So Angola is a tab 25.
Tab
25.
25.
Of the authority. And it was a case about online posting. At page 541, just above paragraph 10, in italicised words, the appellant's NBC postings. What had happened, we're told, in September 2015, the appellant in that case had posted a series of comments on his Facebook account about a prominent news story on MSNBC, and it concerned a matter of an individual who had been imprisoned for contempt of court because she had refused to issue marriage licenses to same-sex couples because of her Christian religious beliefs about same-sex marriage. So that was the underlying story. And the appellant, we're told, had contributed around 20 posts to the MSNBC Facebook website in response to comments by others. The appellant's comments included statements and observations expressing views on same-sex marriage and homosexuality, and we see them set out there. For instance, it says same-sex marriage is a sin, whether we accept it or not. Homosexuality is a sin, no matter how you want to dress it up, and it goes on in this vein. And at paragraph 11, he also included a number of biblical quotations, some of which contained strong language. And there are quotations there from Leviticus and from Jude and from Romans. So this is a case, in fact, in which Mr. Ngole directly relied on the Bible in support of the views that he was expressing. And if I can then turn forward in the authority to where the tribunal, this court, at page 558, deal with the judge's findings. And there is a heading, the Article 10 issue. And then 61. The judge began her full...
So sorry, which page?
I'm so sorry, my lord. Page 558.
Sorry, I thought you said 548. Yep.
Paragraph 61. Under the heading, the Article 10 issue. The judge began her full and meticulous judgment by considering whether the appellant's Article 9 rights were engaged. She considered a number of authorities, but did not find them to be directly applicable to the issue in this case. The postings were found to have been a religiously motivated contribution to a political debate. It was not a protected manifestation of religion. In such a context, it was accepted that the university's decision was not an interference with Article 9 rights. The case was then considered on the basis of interference with the right to freedom of expression. Under Article 10, the judge accepting prima facie interference and proceeded to consider the lawfulness of that interference. It was noted, however, that the religious dimension of this case remained legally relevant and would have a bearing on the lawfulness of the interference with Convention rights to freedom of expression. We find this to be the correct approach in this case.
Not much discussion. Do we have the judge? We don't have the judge's judgment.
We do not have the judge's judgment.
It's presumably available on Bailey.
Which presumably is available on Bailey, and if my lord, you would like to see the
well, I don't think we're perfectly capable of looking at it for ourselves. Speaking for myself, there's no reasoning here, but arguably they're endorsing the judge's reasoning.
Yes.
Do we know whether this point was actually challenged by? Well, it would be by Mr. Darman.
Yes.
Well, there we are.
Yeah. So this is
But-
that is the reason I take you to Ngole, because it is somebody speaking out at a debate. In fact, going further than Mr. Page and relying directly on the Bible in support of those views. And this court says that is contribution to religiously motivated debate. And we agree with the judge when she says that doesn't fall within Article 9.
But I don't quite see why, speaking for myself, I don't find why the mere fact that it's a religiously motivated contribution to a political debate means there's not a sufficient nexus. There may or may not be.
Yes.
Without seeing the judge's reasoning, we can't see what this court was endorsing.
But I've taken the court to Ngole because in support of the submissions I've just been making to you, which is to say, well, actually, if it's not the speaking out in the sense that I postulated of, I believe as part of my religion that I'm required to speak out to spread the word of God, and if all I am doing, in inverted commas, is contributing from a religious motivation to a debate, then one doesn't fall within
Yeah,
the
well,
ambit of
I see what you say. I'm just at the moment don't quite understand why it's right, but
The fact that it happens to be a topic of political interest and social controversy can't, as it were, shift everything into Article 10. I mean, the fact that something is a political debate doesn't of itself, as it were, neutralise the religious element, surely.
No, I'd accept that, my lord. I don't think that it can be said that simply because it's a controversial topic or a topic of the day, that means it can't be a manifestation of religion, that's not going to be something that disqualifies it from being a manifestation of religion. But one would want to look quite closely at what was being said.
But I'm sorry, I interrupted you. If you wanted to add something.
All I was going to say is what was being said, and if one can put it that way, what is motivating that contribution, and that would be something that you'd need to look at. And this tribunal, I say, was entitled to take the view that what Mr. Page was doing was not a manifestation of his religion.
Well, can we contrast, if there is a contrast, this case with Ngole?
Yes.
One might say that Mr. Ngole's contribution was, as it were, a gratuitous contribution to whatever debate was going on the net, in that he chose to join in.
Yes.
Mr. Page's situation is somewhat somewhat different. In other words, that he was, in a sense, on television as being the magistrate who had been sacked.
Yes.
And in his opinion, leave aside all the other issues in this
Yes.
case, because of his Christian beliefs.
Yes.
And so, you know, Mr. Ngoli might have been involved, but Mr. Page was committed to this issue. It was an issue that directly affected.
Well, plainly in Mr. Page's case, he has been dismissed from the magistracy.
Yes.
But I don't think, speaking for myself, my lord, that I would regard that as a point of distinction between him and Mr. Ngole, because if what Mr. Ngole says he is doing, well, we can see what the comments are. He is expressing views, his views about the sinfulness of homosexuality and relying on the Bible. And that is said not to be a manifestation of his religion. Whether one is directly affected or not, I don't think can be the dividing line. The question is, what is it that somebody is doing by making those comments? Is one manifesting one's religion or not? And if Mr.
I'm just making the point, I follow what you say, but
Yeah.
making the point that Mr. Page is not, in a sense, making his comments. He's defending himself
well,
in the public arena, having been publicly sacked.
yes, I mean he's invited to participate in a television programme, and he chooses to participate in a television programme.
Well, that gives rise to other issues. We'll come to the fact that the manner of, as it were. But the question is whether this is an expression, manifestation of his religious belief, and is it irrelevant that, in a sense, what he's doing is holding up his end of, explaining his end of the argument in a public arena when he has been put into the public arena by being dismissed publicly.
Yeah. And my lord, that might be an evidential factor that would point one in one direction or another. But just as your lordship put to me, the question of whether one says it privately or publicly isn't the deciding factor, nor do I see that it can be the deciding factor whether one is answering questions in relation to one's own position, or to use my Lord Justice Underhill's example, the bishop who goes on to the television programme in order to express views about the desirability or otherwise of gay marriage. These are, I don't think that these are factual points that can provide the touchstone, if I can put it that way, as to what is and is not a manifestation of religion. We know the touchstone is the test in a wader, but what I would suggest is when one looks at Article 9 and what Article 9.1 is intended to protect when one considers manifestation, then we do need to be cautious when we're talking about public statements or statements, forgive me, on issues of debate, and one does need to look closely at whether or not that is somebody, as I say, speaking out because that is a manifestation of their belief, or simply answering questions about their position.
Can I just tie up a loose end about it, Ngole? I think, speaking for myself, I will certainly want to look at what Mr. Collins Rice, as she then was, said. But probably it would be appropriate to ask both you and Mr. Diamond to submit short submissions, if you wish, about the relevant part of her judgment.
Yes.
And to indicate what you say the relevant parts are. It may be perfectly obvious, but not having seen it, I'm not sure.
Of course. And I'm grateful.
Can you both do that by, certainly by the end of Friday, sooner if possible?
I'm sure that can be achieved.
Very well.
I was then just going to say something briefly about the engagement of Article 10 before talking about interference, because interference really is a topic that is common to both Article 9 and Article 10, if that's convenient to the court.
So sorry, we've taken a long time, but it is an important point. You're dealing compendiously with convention rights, therefore both Article 9 and Article 10. On Article 9, you we've been debating whether or not it was engaged, whether the tribunal was right in its primary decision that it wasn't engaged. You're now coming back to justification, presumably.
I was proposing to deal with that, and if that is convenient to the court, if the court would prefer me to deal with interference now.
No, don't mind at all. I just want to make sure which direction we're going.
Yes.
So we're now dealing with interference.
Yeah, what I was proposing to deal with was the Article 10 question. We've looked at Article 9 and whether or not Article 9 is engaged.
Yes.
Were Article 9 engaged, then plainly there has been interference with Article 9 because there has been a decision to remove Mr. Page from his position as a non-executive director. And I wouldn't seek to persuade this court otherwise. I mean, the question would then be a question of justification for that interference. But what I was proposing to come to was Article 10, because there's a distinct argument that's being advanced to this court. And indeed, Mr. Diamond, in his submissions, as I understood him, placed much more focus on the engagement of Article 10, in fact, than he did on the engagement of Article 9. But the difficulty that he undoubtedly faces in the Article 9 issue is that it wasn't argued before the Employment
Do you mean Article 9 or Article 10?
Article 10, forgive me.
Yeah.
Article 10 wasn't argued. I'm not saying that it wasn't an issue, it was plainly put an issue. But the tribunal said, well, we weren't really addressed on Article 10. And they deal
Well,
with
I can see that's a problem, but if it was formally an issue, which I think you accepted, and an advocate, for whatever reason, in experience, doesn't choose to advance any submissions,
Yes.
I don't think that's an absolute debarment from dealing with the point, is it? That if it's been abandoned or even tacitly abandoned, that's fine. But if you have I don't know anything about Mr. Stroilov, but if he was an inexperienced advocate and just doesn't deal with the point properly, but there are submissions on paper about it, then it's a live point, isn't it? It needs to be dealt with.
I accept that, my lord, but to descend to fine criticism of the tribunal about how they deal with it when a positive case isn't put to them, I think is...
Well, that I accept, but you're not saying that the mere fact it wasn't dealt with, covered in the oral submissions, you're not saying that means that's the end of the story.
No, I
accept.
No, I do accept that. Because, and one can, and I don't think I could say that, my lord, because if one looks at page 318, paragraph 60, a submission, it's not a developed submission, but it is said in oral closing submissions by the claimant's representative that the starting point was Articles 9 and 10, so it's clearly not abandoned the point. And then the tribunal notes that Article 10 is mentioned in the ET1, it's in the written opening, and there's reference to the Fuentes-Bogo case, but no clear argument based on Article 10 was developed, and they record, and this is 6 lines up from the bottom, what was put to them.
Sorry, where are we?
Forgive me, paragraph 60, page 318.
Yep, thank you. Yep.
So it is, as I say, I think 6 lines up from the bottom, a sentence that starts in oral submissions. The extent of the argument was, in effect, to say that Articles 9 and 10 are engaged in this case, and the Equality Act must be construed so as to comply. So that is what's put to them. And then they deal with it at 61. They say, notwithstanding all the deficiencies in what's been put to us, 61. Nevertheless, the tribunal has considered whether Article 10 adds anything of substance to the claimant's case. The tribunal notes here that Article 10 was also raised in Trehorn, but as in this case, in parallel with arguments under Article 9, those arguments were rejected, and they say at 62 they're doing the best they can to analyse the case, a case that's not
But
really developed.
I'm being slow about this. That if Article 9 was not engaged,
Yes.
well, if Article 9 was engaged, which is not in the end what the tribunal found, but obviously Mr. Stroinoff wouldn't have known that, I incline to agree. I don't at the moment see what substantive difference it makes. In that case, it'll come down to justification, and I wouldn't have thought the justifications were very different, subject to any point you may be going to make. But if Article 9 is not engaged, then he's got to put all his eggs in the Article 10 basket, and then it adds a lot.
But
Am I missing something?
yeah. Well, what I say in I take your first point, my lord, and I agree with it. If Article 9, that really this is a case which sort of stands or falls together. But the difficulty for the appellant is that Article 10 doesn't really take this case anywhere. And the reason I say that is because, of course, Mr. Page couldn't rely on freestanding convention rights
I see.
before the Employment Tribunal. He couldn't because the Employment Tribunal has no jurisdiction to deal with complaints of breach of the convention.
Yes.
What he has got is a claim under the Equality Act. And what the Equality Act does is protect his religion or
Well,
belief.
fine, I'm sorry, but we may be at cross purposes. I understand that point,
Yes.
and I knew you were coming to it.
Yes.
But you're defending the tribunal saying it doesn't add anything.
Yes.
Well, the point you're about to make, or just trailed, is the convention rights don't add anything.
Yes.
But if the convention rights are capable of adding something, then Article 10 is important if Article 9 isn't engaged.
But the submission that I'm endeavouring to make, my lord, is that Article 10, in and of itself, can't unlock the puzzle for Mr. Page. What conventionally, if I can put it in that way, happens in these type of cases is that people rely on Article 9 and Article 10 together. I mean, Trayhorn is another example of that. But logically, one has to put it into the analysis of the Equality Act, because what the Equality Act doesn't have as a protected characteristic conscience or thought.
It might feed into the victimisation claim. Well, actually,
I'm not sure.
No, I'm not sure it does.
It does. But that, broadly speaking, the law is not concerned with what you choose to say. If what you say is a manifestation of your religion, then it does, because Section 10 and Section 10 protects religion or belief as a protected characteristic, and then there are these sort of customary panoply of ways in which you can be discriminated against, speaking very broadly, because of your religion or belief. But there isn't such a thing as being treated less favourably because you exercise your freedom of expression. Freedom of expression, Article 10, only helps you where that speech is religious in character, and where that religious character is a manifestation of belief. And that's why I say that the Tribunal is absolutely right to say that Article 10 doesn't add anything, because it is not capable of changing the nature of what it is Mr. Page is complaining about, which is, on his case, action taken against him because of a manifestation of belief. And that is why I say that the question of the engagement of Article 10 is academic.
Yeah, thank you. I'm not sure that's what the tribunal was saying, but I see it's what you were saying.
And that brings me into the question of justification, because convention cases, of course, simply look at whether rights are engaged and whether there's been interference with rights, and if so, whether the interference is justified. That is, if I can put it that way, the four corners of their inquiry. they don't look at questions of less favourable treatment. They don't look at questions of a provision, criterion, or practice. Because that is the language of the domestic legislation. And the sole reason that we are interested in the question of justification for interference with convention rights is because if the interference with convention rights is justified, then that affects the question of whether one is looking for a convention-compliant construction, because the rights which have been held to be engaged have been found to be permissibly interfered with in the particular case. And this is where one comes into the 9.2 point that my lady debated with me a short while ago, and the same points arise in relation to 10.2. And the court, of course, will be very familiar with what the interference inquiry is. One is looking at whether the limitation is prescribed by law, whether a legitimate aim of the type identified in the relevant articles is fulfilled, and then, of course, finally, whether interference is necessary. I've put in my skeleton argument what I say about the first two of those inquiries, and Mr. Diamond didn't develop any oral submissions in relation to that, so I may rely on my skeleton in relation to those points. I should, for completeness, on the question of that first question of limitation prescribed by law, I have referred to the norms of public life, I've referred to the public sector equality duty. I think for completeness I should also refer to the equal opportunities policy, which Mr. Page accepted he was obliged to follow, and that you will have the relevant material to paragraph 11.8 of the judgment. I took the court to it yesterday. Mr. Diamond, however, did say quite a lot about necessity for interference, which involves consideration of proportionality. The court will recall that I took you doubtless too slowly through the findings of fact yesterday, but where one sees the story play out in terms of what the trust tries to do in order to resolve the situation, and that this is one of the areas in which what the trust does comes into play. Mr. Diamond put various decisions of fact before you about cases in which interference may or may not be thought to be proportionate, and he referred in particular to Smith and Trafford, he referred to the Livingstone case, and he also referred to Angola, which we've looked at briefly this morning. Now, Smith is not a religious discrimination case at all. It's actually a very unusual case, which sort of pops up periodically, because it wasn't a tribunal claim at all. It was actually a claim in the civil courts for breach of contract. And the argument in Smith was whether what Mr. Smith had done in posting things on Facebook could be said to amount to a breach of contract, which then justified his employer from demoting him. So then they didn't have a general right to demote him. They could only demote him if he could be shown to have acted in breach of contract. And so I don't think that Smith really helps in relation to the issues in this case, because it isn't a tribunal claim at all. Much less is it a claim considering religious discrimination. Livingstone is also not a religious discrimination claim, but it may be just worth looking briefly at what the court says in Livingstone. It is tab 9 of the authorities one. And it is, Mr. Diamond says, the rather infamous case of Ken Livingstone and his comments to an Evening Standard. But the case itself, and one can see this just very briefly at 153, that it was an appeal pursuant to section 79, subsection 15 of the Local Government Act by Mr. Livingstone, who was then Mayor of London, against the decision of a case tribunal which decided that he had failed to comply with the code of conduct of the Greater London Authority. And the conduct in question were his remarks to the Evening Standard journalist. The relevant passages of the code are set out at page 160, paragraph 18. And this is the reference to the Local Authorities Model Code of Conduct, England Order 2001, which had been adopted by the Greater London Authority. And it says, number 2, a member must treat others with respect. 4, a member must not in his official capacity or any other circumstance conduct himself in a manner which could reasonably be regarded as bringing his office or authority into disrepute. And one of the important issues before the court was whether what Mr. Livingston had done was in his official capacity, so that the code applied to what he had done at all. And at page 163, paragraph 30, they say that the tribunal correctly decided that the appellant was not in his official capacity when he made the remarks in question. It is not, in my view, even arguable that when making them, he was performing his functions as mayor. Thus, there is no reason to remit the case for any reconsideration on its true construction. Paragraph 4 of the Code of Conduct did not apply to what the appellant said, and so the finding by the tribunal had been a failure to follow the provisions of the code cannot stand. And then they say, the court says finally, 165 paragraph 38, that it's the burden is on the defendant to justify interference with freedom of speech. However offensive and undeserving of protection the outburst may appear to some, it's important that any individual knows that he can say what he likes, provided it's not unlawful, unless there are clear and satisfactory reasons within the terms of Article 10.2 to render him liable to sanctions. And they said that the court said the tribunal misdirected itself in deciding it was proportionate for the code to extend as far as it did. The restraint was not shown to be necessary in a democratic society, even though the high level of protection appropriate for the expression of political opinion was not engaged.
Can I just ask, this is the model code of conduct which applies to all local authorities?
Yes.
There is no equivalent for NHS bodies?
I don't believe there is.
No, that's fine.
I said that there are certainly provisions now on fit and proper persons and what makes you a fit and proper person.
Yeah, that's a slightly different...
But I think
no,
but yes, sorry, I just trying to think that, but I don't think that there is a model code of conduct, a statutory model code of conduct of the kind that we're concerned with.
But obviously bodies will have their own internal code, yeah.
And certainly none is referred to in judgment.
Sorry, I was just really... I think what I was thinking of was the extent to which there is a useful parallel between the code of conduct statutorily imposed, or at least by secondary legislation for local authorities, and the non-statutory code we've seen for members of NHS bodies, but they're not the same. No.
But the short point I'm endeavouring to make by reference to Livingstone is that the problem, if I can put it in that way, in Livingstone, was that the code of conduct just didn't apply. It was conduct which he had left, Mr. Livingstone had left the reception. He'd been doorstepped, as the court puts it, by the Evening Standard. They say that when he's leaving, then he is no longer, he's not acting in an official capacity, and the code of conduct doesn't apply to him, and therefore it is not justified to apply a sanction to him by reference to the code of conduct when that relates to a behaviour in his private life.
There is at paragraph 11.8 of the tribunal's decision, as you showed us yesterday, the Professional Standards Authority that issues standards for members of NHS boards.
Yes.
There'd be a parallel with that.
There would be a parallel with that, my lady, but the difference I think in our case, was that it was accepted that those were relevant and applicable standards to Mr. Page, whereas in Livingston it was very much an issue whether or not the code of conduct.
Well, how
was
is that so?
applicable.
I mean, I'm not sure how this is helping you. Mr. Page wasn't appearing as a trust employee on television. I mean, on one reading, the standards under 11.8
Yes.
might make it impossible for anybody who holds Mr. Page's view to be a non-executive director of a trust, or indeed an employee of a trust at all.
Well, my lord, what those standards 11.8 mandate is that when you are a non-executive director, then it is important for you to maintain what I think might broadly be said to be neutrality in public life, and not to make statements that call into question whether or not you are approaching matters in a neutral way without preconceptions about particular groups. Whether that is whether or not you do have those preconceptions, whether your conduct gives rise to that perception. And then finally,
I'm grateful to my lady for reminding us of 11.8. I think the reason I hadn't stuck is, of course, we don't actually have it. We have, and I raised this point with you yesterday, we have various propositions which the claimant accepted, which are
Yes.
said to be drawn from a mixture of that and the equal opportunities policy,
yes,
which don't all look as if they're direct quotes. It looks as if they're more paraphrases, I don't know. I think, I'm sorry to add to the list of things that we ought to have, for background only, and not because obviously we would make any finding that wasn't within the four corners of what the tribunal had found. I would like to see that
yes.
those standards.
And they're applicable across the board, not just to this particular
Yes.
NHS board.
I think, my lady, what I'd say,
The first sentence in
the professional
11.8.
standards, the standards for members of NHS boards and clinical commissioning group, that will be, I anticipate, of general applicability.
Yes.
The specific equal opportunities policy of
Yeah.
the trust.
Well, we'd better have both.
Yes.
And again, don't feel obliged to make submissions about them, but knowing that we're going to look at them, if there's anything you want to draw our attention to or say, please do so by the same timescale as I said for the...
And then, of course, the court has, in my skeleton, the reference to the public sector equality duty and the obligation on the trust to promote equality of opportunity between different groups, and the reference there to Preddy and Bull, all of which I would say is also relevant to the question of limitations prescribed by law.
Thank you.
But finally then was Ngole, which, as I say, we've looked at briefly this morning. And Ngole is tab 25, because the reason Ngole succeeds, Mr. Ngole succeeds, is on the proportionality analysis, in which this court that says that the court below had got it wrong. Because what had happened was that in consequence of the Facebook postings, there'd been fit to practice proceedings because of the nature of the course that he was on, and he had been removed from the course altogether. And at page 567, the court turns to the question of proportionality from 107 onwards.
Sorry.
But if I may, just before I come to proportionality, just going back for a moment, because immediately prior to proportionality, the court deals with the question of legitimate aim, It starts at 104, but the relevant passages that I would like to take this court to are at 105, 106. And they say it must equally be the case that the obligation to maintain confidence cannot extend to prohibiting any statement that could be thought to be controversial or even to have political or moral overtones. And then dropping down, the existence of a broad legitimate aim is a mere threshold to the key decision in this case. As in almost all cases, it must be such a legitimate aim must have limits, it cannot extend too far. In our view, it cannot extend to preclude legitimate expression of views simply because many might disagree with those views. That would indeed legitimise what in the United States has been described as a heckler's veto. Mr. Diamond refers to this passage in his certain argument. But he doesn't refer to 106. On the other hand, the legitimate aim of such regulation must extend so far as to seek to ensure that reasonable service users of all kinds perceive, and I emphasise the word perceive, they will be treated with dignity and without discrimination. And it goes on to say, as the guidance in that case made clear, the appellant had an obligation not to allow his views about a person's lifestyle to prejudice his interactions with service users by creating the impression that he would discriminate against them. So I just draw the court's attention to that passage because it is legitimate in the analysis of why, factually, why the respondent does what it does, and therefore the legitimate aim that they are pursuing.
Doesn't.
I'm sorry.
My lord can go first.
Thank you. The position of a social worker is one where, on a level of dealing with a particular family problem,
Yes.
individual's problem, a social worker has a very great deal of clout. Of course, within a system and within a management structure.
Yes.
But the opinion of the social worker who does the groundwork is very influential.
Yes.
Now, two things. Firstly, is there some distinction to be drawn in this case where Mr. Page is not an operative independently? He's one of a large board on which no doubt there's a very wide range of views. Second issue for you to help me with, if you would.
Yes.
How does this differ from cases like, is it called Vote or Veit or something of that sort, the German teacher who had
Yes.
very far-right views?
Yes.
And other such cases.
Yeah. So I think to deal with the first point first, does it matter that he's one of a number? I think directly the answer is no. And in some ways it might be said actually that this case is more difficult for the respondent to handle than the case of the individual, because at the end of the day, if you're a non-executive director, you are speaking for the trust in a way that an individual is not. You are.
Well, how? In what context do you speak for the trust?
Well, when I say that, what I mean is that you are seen. You are a member of the board of the trust, which will be a mix of executive and non-executive directors. But by virtue of having that position, you are in a position of authority, and you may well be perceived by the public as being the trust, as standing in the shoes of the trust.
Would you be reasonably perceived?
I think it would be reasonable for you to perceive it in that way, and certainly we know in this case that there was a perception, certainly, and it's not said to be an unreasonable perception, by the LGBT Staff Association of the Trust, that if the Trust doesn't distance itself from this view, this might
they're not
be
allowed,
seen to
on the LGBT group's view, they're not allowed to harbour him, was the word that they used.
Well,
And so isn't the public in that area capable of understanding that on a board there will be a range of views,
Well, I think...
And if those views are entitled to respect in a democratic society, that the board should be able to encompass that range of views.
Well, I think, my lord, some people...
Particularly, I keep interrupting you, where there is no evidence at all that it would, that this particular director would use it in a way in order to disadvantage people.
Well,
Distinction to the other case.
To try and sort of draw those threads together, some people might and some people might not understand how an NHS trust works, and the range of directors that are said to be involved. But I do take issue with the proposition, my lord, that actually what this is to say, unless you think in a particular way, you can't have a place on an NHS board. That isn't what this case is about at all. And at no point did the respondents say, because you hold Christian views, out you go. That wasn't this case at all. The difficulty and the problem arose when Mr. Page expressed views in a public forum that might be thought to be indicative of a level of prejudice or a level of bias. Whether they were or were not, that was the problem. And that was not a hypothetical or notional problem. It was a real problem. There was the complaint, but also there was the specific evidence in this case of the difficulty of engaging with the LGBT community, and a real concern, which the tribunal accepts, that the expression, not the holding of the view, but the expression in this case could lead to the difficulties that the trust has experienced in engaging with the LGBT community and getting them to engage with services.
So what's the status of this complaint? What is the mechanism for such a complaint? You've referred to the complaint by the staff group.
Yes.
So what mechanism of complaint is that?
Is it a dignity at work type complaint?
Directly, I don't know.
There's an email from the group.
Yeah. What we know is what is of course in the judgment is that the complaint, a formal complaint, was made to the chair.
Yeah, I think.
Yeah, we've got it in the supplementary.
Page 12, I think.
I'm grateful.
Oh no, that's the judicial conduct.
Oh, I was convinced I'd seen it.
Sorry.
Maybe it's quoted.
It is quoted from, certainly, but
Oh well.
didn't think I had seen.
No, I must have. It must be false memory syndrome.
It is certainly referred to in the decision.
It may have been referred to in.
Well, it's at page 51 of the supplemental bundle.
Letter of concern.
In the witness statement.
Yes. It's quoted.
Ah, yes. Well, we're both right. It's not there as such, but it's quoted in full.
Yes.
Yeah.
And it's quoted in the witness statement of the recipient of
Well,
the
it's
complaint.
described as an email, and it's described as a concern.
Yes.
So I'm just wondering what led it to be. What led it to be earmarked as a complaint, as if there was some formal status attaching to it.
I don't believe, my lord, it has. Just looking at the way it's. Doing the best I can, my lord. I don't think that I can point you to a policy pursuant to which this email has been written, and therefore I don't think that concern or complaint are being used as terms of art. What the email says, what it says, and it's the substance of that email.
It's clear evidence that a person and as a representative
Yes.
said was distressed
Yes.
by the views and was concerned about the reputation of the trust.
Yes. Yes.
But is that enough? It's repeatedly said about freedom of speech that it includes the freedom to say things which will upset or distress
Yes.
people. And one can well understand why a gay person would be distressed by hearing the views
Yes.
that Mr. Page expressed. But unless those views can be said as not worthy of respect in a democratic society, which is not how anyone has put it, you have sometimes to put up with being upset and distressed.
Well, sometimes you do, but not always. What we have in this case are two ingredients. There is the email, let's put it that way, in a neutral way, in which the views that have been expressed by the chair of the LGBT staff network have been expressed. But the other aspect of it is the issue of the impact on the patients of the trust.
Well, that's why I think we need to be quite careful. The members of the staff being upset and distressed is one thing.
Yes.
I accept there's potentially an impact on the availability of the services of the trust
Yes.
to is there a correct patients seems slightly the wrong word, but service users sounds mealy-mouthed.
Yes, I think that because this was a mental health NHS trust, and certainly in my experience, mental health NHS trusts do refer to service users.
Okay, well, I'll use the phrase.
And I think they prefer not to talk about patients because
Well,
it's stigmatising.
I thought I was sensitive to that, but service users sounded a bit odd anyway. But if that's the received phrase, let's use it. Service users, I mean, that is a different point from upsetting staff, and it's a different point from bringing the trust into disrepute in some general sense, that people who don't share Mr. Page's views would say, why have they got someone like that on the board? To which, if that was all it was, the answer would be tough, wouldn't it?
It might be said to be tough, but of course, if the concern is you've got somebody on your board who isn't being neutral in public life, that is not to suggest for a moment that people aren't entitled to hold views in public life. You'd be upset. You can't police people's thoughts.
No, we're talking about expression here. But why does the fact that you're on an NHS board mean that you can't express controversial opinions about things which don't directly concern the board, although they may be socially very divisive? Because
what is said here is not... Yes, of course, it is about the magistracy directly, but it's about a view and an opinion about certain groups within society, groups who the trust deal with as well, and the implications of what is being said for how it might be thought that you would approach decision making in relation to those groups. That is why I say it might not be good enough to say, well, you can say whatever you like and tough, you have to put up with it. If actually what you say causes concern about your neutrality, then that is
what do you mean by neutrality?
Well, that you approach everybody in the same way without preconception.
That would mean that no NHS trust could have on its board an Orthodox Jew, certain sorts of religious beliefs such as observant Muslims, who hold beliefs which are not shared by everybody, and that those people could not express their views.
It's the expression of views rather than...
But it would mean that if you were
yes.
a holder of any religion, not just Christian, some Christians, if you were a holder of such views, you would not, by accepting a position as a non-executive director of a trust, you would be unable to express those views in any public context.
If what you said gave rise to concern about the way that you would go about dealing with people, yes.
But would it, I mean, is it realistic to think that it would give rise to a concern about how you would go about dealing with people?
Well,
Reasonable concern.
Well, reasonable, I say yes, and the reason I say yes is because we actually have specific evidence in this case. It's not a hypothetical one, but there is a specific concern being expressed here by the chair of the LGBT network of the trust. That is
Well, we'd have to look at what he or she said.
Yeah.
We've got the quote. We've
We've
got
got the whole thing
We've got it.
in the witness statement, but
We do.
let us suppose that they expressed that view. It's not much evidence in itself, is it? You would expect some, and I don't mean this in any way disrespectfully, you would expect a committee member of an interest group of that sort to be peculiarly sensitive to these matters. It's their role to be so, but it doesn't mean that you have therefore to accept their view about what the risk was of unequal treatment.
No, I don't seek to suggest that that view is determinative, but I rely on it in support of my argument that it's not an unreasonable view to hold. That if somebody expresses publicly the views that gay sex is wrong, that same-sex adoption is wrong, that does legitimately give rise to a concern about how that person interacts potentially with people who come from those groups.
I appreciate this about expression, but can I go back to one of the instances that I gave you?
Yes.
If you would take a person of Orthodox faith, perhaps Orthodox Jewish faith, one could take it as read that issues such as homosexuality, transgender, same-sex marriage, all of those things would be completely unacceptable as a point of clear doctrine. Now, starting from that point, why would the trust not get a letter of complaint as soon as it appointed somebody of that sort to the board?
If they express their view.
Well, their view might be expressed by their very being.
Well, my lord, of course, they might subscribe to those views. They might not. One wouldn't want to make assumptions.
Well,
about people.
one could make assumptions in certain particular categories.
Which assumptions might, in a particular case, be more or less reliable. But I think the difference, the distinguishing factor in this case is the expression and the public expression. The public expression that there are certain groups of whom, and this is probably not a particularly elegant way of putting it, of whom you do not approve, and the willingness to say that publicly is the thing that gives rise to the concern, not the mere holding of a religious view, which may or may not align itself with views of that kind.
Is it relevant that the tribunal found that it was of particular importance to the appointments body in reaching its decision that the appellant expressed an apparent inability or unwillingness to distinguish between his personal views and what was appropriate given his role as a non-executive director?
I would say, my lady, certainly yes, because what I think as an individual and what I say publicly are two different things.
But the mere expression of one's views publicly may not be enough to create the concern. It's the expression, or is it, the expression of one's belief and an indication that one is not going to put aside that belief when one is approaching one's duties, be it magistracy duties or non-executive director duties.
Yes, I think, my lady, yes. I think that is right. It may be that the court doesn't accept the proposition that simply saying it and holding an office is sufficient. I accept that. But I think that there are, on this point, parallels between the Lord Chancellor appeal and this appeal in the blurring of the boundaries, in not seeing that there are things that one can think as a matter of personal conscience and an approach that one must take to one's duties in a public office.
Well, I was referring to 11.43, the first sentence in this case, on page 300.
That appears to be a quote, more or less,
Verbatim
precisely from the letter.
Yes, because 11.4, and because my Lord Justice Peter Jackson expressed concern yesterday about to what extent the tribunal had been faithful to the decision letter, and so I checked overnight, and 11.42 and 11.43 do faithfully replicate what is in the letter.
Yes, I mean, the oddity, I think they do. The oddity is that when later in its discussions, the tribunal characterises the reasons, they don't really marry up to the reasons set out in the letter. There's a family resemblance, but they're expressed differently. The emphasis is put differently. Some points which are in the letter aren't mentioned by the tribunal.
Yes, and I was going to do a sort of a marrying up exercise in due course.
Okay, well, come back to it when you do. Just before we leave this area, I don't want to lose sight of it totally. A little while ago, we were on Ngole.
Yes, we were.
And you relied understandably on 106.
And then I was about, my lord, to go on to proportionality.
Well, before you do, the way it's expressed in the third sentence is the use of aggressive or offensive language in condemnation of homosexuality or homosexual acts would certainly be capable of undermining confidence, and one absolutely understands that. But I think it would be said that what Mr. Page did here, while he certainly faithfully stated the scriptural, well, perhaps he didn't quite, but certainly referred to the fact that homosexual acts are a sin.
Yes.
He did so in. He didn't do so in aggressive or offensive language, unless it can be said that merely stating that that is the view of the view expressed in Bible is itself regarded as offensive.
Yeah, I take that point. I don't, for my part, read 106 as saying that only aggressive or offensive.
No, but it doesn't take you all the way home. If it said any statement that homosexuality was sinful would certainly be capable of undermining confidence, that would obviously help you.
No,
and it doesn't say that.
It's a question of what sort of statement gives the. I think I would sort of place my emphasis on the first sentence first. The illegitimate aim of regulation in that case being fitness to practice regulation, must extend so far as to seek to ensure that reasonable service users of all kinds perceive they will be treated with dignity and without discrimination. That's the touchstone. And so what one is always doing is looking back and saying to oneself, is what we have here something that gives rise to a perception on the part of the hypothetical reasonable service user that he or she will be treated with dignity and without discrimination.
In what context, where it says at the end, for example, mustn't create the impression that you discriminate against somebody, in what context as a non-executive director, would somebody in Mr. Page's position have the opportunity to effectively discriminate against somebody?
He could, on an individual basis, my lord, I suspect it would be difficult to. No, that's not right. Because there are two things that I can think of. One, of course, is he would be part and parcel of the board, and he could, hypothetically speaking, advocate for termination of mental health services for people from the LGBT community. This is, I'm not suggesting for a moment that's what he would do, but that would be an example in which he could, through his role, discriminate. But on an individual level, non-executive directors do deal with individuals. An example would be, for instance, and I know this from my own experience, when NHS trusts discipline doctors under the national scheme, which is called Maintaining High Professional Standards in the Modern NHS, a non-executive director is designated to the case. They are a designated board member, and they make individual decisions about the case of an individual doctor in relation.
Right. So it could have been said in dismissing him that you're somebody who might have attended a board meeting and persuaded the board to take some homophobic steps. Or it could have been said, well, we can't possibly have you on a conduct panel because you've got preconceived views. Or would it just be a conduct panel involving somebody from a gay background that you couldn't possibly sit on such a conduct panel? But that's not what happened here.
No.
Instead, it's been done because of the impression created with a sector of the public. No, let's call them service users. In fact, because your concern was apparently that they wouldn't become service users.
Yes.
Because of issues of this sort. But surely the creation of an impression has to have some. It's got to have its feet on the ground, surely. It's got to be that the person who's offended by these views or who is worried by them has got to think, well, how is this person going to use his public office in a way that would be detrimental to this group?
And forgive me if I'm not answering your question, but if by that one is saying, well, you know, the respondent had to be able to put evidence before the tribunal of such a person who said, well, I might have taken up, I might have made use of the trust services, but because of what was said, I didn't. I think that is a counsel of perfection. And
no, it wasn't that. It was the lack of. I'm suggesting this to you. I'm not saying there isn't an answer to it, but the lack of any, as it were, concrete explanation within the decision as to what it is that somebody like Mr. Page is capable of doing that is actually likely to be a proper example of how he would be discriminating against others.
Well, I wouldn't, and I think we may have explored a little the things he could do, and I stress the hypothetical examples. But one might say that actually the meat of this, the difficulty of this, is the fact that he is a non-executive director. He is seen as somebody who is part of the trust, the guiding mind, the guiding will of the trust, and what that says about the trust as a whole, not just Mr. Page specifically, and whether the trust as a whole is by saying, well, effectively, by not taking action, saying, well, that's okay, you can say those things, we don't mind.
No, the trust could perfectly easily put out a statement saying we don't agree with this at all. That Mr. Page is one of, whatever it is, 16 or 20 members of the board, and we're a broad church.
They could. That is one thing they could do. But that, I think, my lord, wouldn't. I suspect if that is what had happened, then we would have had a case complaining about putting out of a statement, because the putting out of a statement, whilst less having fewer consequences for Mr. Page than his removal from office, it's just it's just another point on this spectrum of response. And so, if one accepts that it is, if one starts off from the starting point that it is legitimate for the trust and by extension the respondent to be concerned about the statement that has been made and about what that means in terms of perceptions of Mr. Page specifically and the trust generally, then the responses, as I say, are that is all relevant to the assessment of proportionality. And what the trust did not do in this case was wade straight in there after the first round and say, right, that's it, you're out, we don't like any of this, off you go. In fact, the trust tried very hard to come up with an accommodation.
Well, I think we must let you get on to proportionality.
Yes.
Well, of course, so far you've been talking about aim,
Yes.
but you inevitably slipped into proportionality. You wanted to remind us of what was said in
Yes,
Ngole
I
about
just wanted
proportionality
to,
while we've got that open, if we still have.
So, Ngole just deals with the question of proportionality. I just wanted to take the court, if I may, briefly to what was said to be the problem, if I can put it in that way, in Ngole itself. First of all, at 109, they deal with the topic of lack of insight and entrenched positions. At the heart of the university's decision to remove the appellant from his course was the finding that the appellant lacked insight, quote, and had become entrenched. And they say at 110, in our view, the university's failure to appreciate two matters mean that it can be described as itself lacking insight. The university failed to appreciate the appellant's apparent intransigence was an understandable reaction to what he was being told by those in charge of the disciplinary processes, namely that he could never express his religious views, such as sexual morals, in any public forum, i.e. there was a blanket ban. And then they say at 111, crucially, at no stage did those in charge of the disciplinary process make the sorry, I think that the syntax has gone a little awry here. At no stage did those in charge of the disciplinary process at the university, I think, make it clear that it was the manner and language in which the appellant had expressed his views which was the problem, or discuss or offer him guidance as to how he might more appropriately and moderately express his views on homosexuality in a public forum in a way in which it would be clear that he would never discriminate on such grounds or allow his views to interfere with his work as a professional social worker. And then they say at 112 that they think that the university quickly became entrenched. So that the university really had this view of blanket ban, you can't say anything in any forum to anybody, and hadn't explained to Mr. Ngole that actually it was the manner and language rather than expressing a view at all. And that is certainly an ingredient in why the court considers it to be disproportionate. And the other aspect that the court deals with, and this is at page 572, they deal directly then with the question of the proportionality of sanction, because Mr. Ngole was removed from his course. And they say at 134 that after considerable reflection that they cannot conclude the approach to the university can be shown to be proportionate. They refer at 135 to the fact that they were the appellant's religious and moral views based on the Bible. And then they say at 136 that it seemed apparent to them that the position as to the condemnation of any expression of such views must have been present in the minds of key players within the university, and that underlying attitude, and then at the top of 573, they almost certainly have led to a too rapid and disproportionate conclusion that removal from the course was necessary, rather than the institution of a calm, continuing process of guidance of the appellant, spelling out what he could and could not properly say and the circumstances in which he could say it. And then essentially they say at 137 that the swift conclusion was unteachable, that it was for him to construe the regulations and guidance, for him to understand the impact of religious language on others unfamiliar with it, and that his failure to do so meant he must be removed immediately, do not seem to us to have been shown to be the least intrusive approach which could have been taken. So I rely on Ngole because the court endorses a distinction between saying anything at all and the manner and language in which you express it, but also that's part of why what the university does is disproportionate. But the other part of it is effectively they jump straight from you've said something, off you go.
Yeah, and your point is that there was a first round in this back in 2015.
Yes.
And in the decision letter, they address, in a sense, these very questions about whether there's a possibility of change.
That might be said to be a very long way round to the question, well, why does any of this matter anyway?
Right.
Because this was not a judicial review, such as in Ngole, relying directly on convention rights. It was a common or garden, direct, indirect discrimination and victimisation claim in the Employment Tribunal.
But just before we get there, perhaps you're going to get there, as you've just tracked, in a sense, the whole of the last hour's debate you're going to submit is irrelevant because this isn't a claim based on convention rights. And you may or may not be right about that. But even if it is necessary to decide whether the interference was proportionate, the tribunal reached a decision on that, which is a decision of fact, which has not been challenged as being perverse. Perhaps you were going to make that point, but I mean, logically, it comes before the one you're about to make, doesn't it?
My Lord, I think that is right, and for completeness, I've also referred in my skeleton argument to the Chief Constable of Greater Manchester Police case, which says it is not for this court to embark on a proportionality exercise of its own unless it thinks...
Well, it's very much for it, but the point's a more serious one from the opponent's point of view than that. It's not that perversity is before us, but we should be slow to challenge an assessment of proportionality.
It's not before you at all.
It's not before us at all.
Yes, I agree, my Lord.
Well, don't take it that I necessarily agree with you, but I want to make sure that that
agree
is an important part of your submissions, but there isn't perhaps very much to say about it.
I agree with the proposition, my Lord, that it is not. There is no appeal. There is, despite the fact that I started my submissions yesterday by saying this is a decision on its fact. There is in fact no challenge to any of the facts before you, and nothing is said to seek to persuade you that the Employment Tribunal came to a perverse conclusion in relation to any of the facts that it was engaged with, and that
including proportionality, which is a factual assessment. Yes,
certainly.
Well, even if we were with you on that, I don't think it means that the last hour has been wasted, because these are important points which we may or may not want to say something about.
Indeed. And it is, of course, the way that the appeal is put, and therefore I think it would be an unwise course of action to say, well, none of it's relevant, so I'm going to say absolutely nothing.
But in any event,
not going to have the last hour of debate.
you've addressed the justification and proportionality issues, but you say they don't arise A, because there's no appeal, that the assessment was perverse, and secondly, the point you're about to make, which is that they don't plug into a claim under the Equality Act.
Yes, and what we may be able to do is short circuit that what would otherwise be the very last section of my submissions relating to justification for indirect discrimination, because effectively I can put it this way: what the submissions I've just made to you apply equally to that domestic question of justification for indirectly discriminatory treatment. And therefore, if one is looking at the convention, I've made my submissions earlier about why I say that Article 10 doesn't take matters any further forward. If Article 9 is engaged and if interference with Article 9 is not justified, then there's the question of how does the convention interplay with domestic legislation in any event. In relation to an indirect discrimination claim, just very briefly, that Article 9 comes in as part and parcel of the assessment of objective justification. And we know that because Mabar says so, and you look, the court of course looked at Mabar yesterday with Mr. Diamond. In relation to direct discrimination, it comes in as in looking at the reason why. And you have, or the court has in its authorities bundle at tab 22, a case called Wasney and East London NHS Foundation Trust. And so it's tab 22, page 482. And it's a decision of Her Honour Judge Eady, as she then was. And it's the case that I touched on very briefly earlier, is the Proportionality.
Sorry, which tab did you say?
22, my lord.
Sorry? 22. 22.
So, Wasney was a case about, just very, very briefly, to give some context, somebody who was a born-again Christian and had essentially taken certain acts in relation to a junior employee of Pakistani heritage and Muslim faith, seeking to, might be thought to be trying to convert her. That was the disciplinary action that was taken in response to that was the subject of a complaint to the Employment Tribunal. Many of the arguments that we've been having today about the convention were also raised in the Wasey case. But in particular, at page 493, the Employment Appeals Tribunal deals with the claimant's reliance on the right to freedom of thought, conscience and religion provided by Article 9 of the Convention. And then it sets it out at 51. There's an important aspect of the case is that Article 9 does not only protect the right to hold particular belief, but also to manifest it. And then at 54 is how the Employment Appeal Tribunal deal with how to marry them up. In domestic law, the expression of right and limitation as allowed by Article 9 of the Convention is most easily discernible when addressing cases of indirect discrimination under Section 19, which may be the more obvious route of challenge in most cases involving the manifestation of a religious belief. Whilst there is no statutory means of justifying direct discrimination or harassment, however, the claimant accepts the limitations permitted by Article 9.2 are relevant to the approach to be adopted to claims brought under Sections 13, direct discrimination.
Is accepts the right word?
Sorry?
Isn't it the claimant argues? Am I being... oh, I see, no. It's slightly odd, but carry on.
And then, so it goes on to say the claimant relies on the protection of the right to manifest religious belief as recognised in a wader. She correctly does not seek to suggest that right cannot be subject to limitation. And then Her Honour Judge Eady says at 55, the concession is in some senses easier to state than apply, but the task will always be made easier by having a clear understanding of the nature of the claim and how it is being put. If the case is one of direct discrimination, then the focus on the reason why the less favourable treatment occurred should permit an employment tribunal to identify those cases where the treatment is not because of the manifestation of the religion or belief, but because of the inappropriate manner of the manifestation, where what is inappropriate may be tested by reference to 9.2.
Yeah, sorry, I'm not picking up your reading, but for the sense of it, you'd ought to emphasise manner rather than inappropriate.
Yes.
Because the inappropriate manner of the
So
manifestation.
that is how one marries
see.
together
Thank you.
the Article 9.2 with questions of direct discrimination, which it's not obvious perhaps otherwise how you would do it, because questions of justification for interference, of course, wouldn't arise naturally, and in respect of a domestic direct discrimination claim. And in this regard, my lord, if I can pick up on the example that you put yesterday to Mr. Diamond in the course of argument, the example of the charity who say, well, we, because of who we are and the nature of our clients, who our client population are, then you can't express views about the sinfulness of homosexuality, even though you may express them in moderate and modest terms. I would say, in relation to that that would not be a case of direct discrimination, because the reason why you're doing what you're doing is not the fact that what you've said is religiously motivated speech, but because of the effect on the client base. And in support of that submission, I hope that you have on the bench an authority that I thought of overnight, the case of ASME.
Yes, I certainly printed it out. I hope it found its way.
I'm grateful, my lord. I also handed up.
Yeah, I've got it. Oh, you handed one up, did you? Yes,
I also
see.
handed
Yes,
one
I
up.
see. Well, I've got it anyway.
And very kindly was accepted, despite the fact that in this day and age, I think, strictly speaking, you're not supposed to. But in any event, ASME is a case about discrimination involving, or an allegation of discrimination involving a Muslim individual. And it is the request to wear the veil when teaching. So what happened in that case was that Mrs. ASME, as a devout Muslim, wished to wear the niqab, which meant that her face would be covered, as well as her head. And the local authority said that they would not permit that to take place. And the reason they said that they would not permit it to take place was because they said that having the face covered would impede communication. Yes, and certainly we may well have had experiences recently with wearing face masks, of the difficulty that there can be with communication if one's face is covered. But at page 1166, paragraph 48, the tribunal sets out the issues that it needs to decide, and Mr. Justice Wilkie sets out the ones that are relevant to the appeal. Number one, does the wearing of the veil by the claimant, which is, no doubt in that case, a manifestation of her religious belief, come within the provisions relating to direct religious discrimination? And then number two, who is the appropriate comparator? The Employment Appeals Tribunal then deals with direct discrimination, starting at paragraph 49, but they identify the less favourable treatment as the suspension for refusing to comply with the instruction to remove the face veil. And then the question arose under the directive whether, by suspending the claimant, the council treated the claimant less favourably than another would be treated in a comparable situation, and whether that less favourable treatment was on the grounds of, because this, of course, is a pre-Equality Act case, so on the grounds of and because of religion or belief. At paragraph 50, that the questions are first whether it's less favourable treatment than would be afforded to somebody else, and second, whether the less favourable treatment was on grounds of religion or belief. And then at paragraph 51, the tribunal below decides that it's not a case of direct discrimination. And at 52, they say there was a dispute before the tribunal as to the characteristics of the comparator. The claimant argued that the comparator should be another Muslim woman who covered her head and not her face. And the tribunal rejected that contention and said that the comparator should be a person not of the Muslim religion who covered her face for whatever reason. That argument is then renewed before the Employment Appeals Tribunal. One can see that at 53, Mr. Dempsey has maintained his argument before the Appeal Tribunal, and there are cases he cites in support of that. And then at 55, the EAT say that in our judgment, Mr. Dempsey's contention is wrong. The purpose of the comparison is to illuminate the answer to the question whether there has been less favourable treatment on grounds of religion or belief. Less favourable treatment in question was suspension.
Well, again, do you want to read the whole of the paragraph?
Could I rather than do this at length, ask the Employment Appeal this court, forgive me, to read paragraphs 55 and 56 to itself?
Yes, thank you. Yeah, I see the argument. I'm being slow about how it relates to the argument before us.
So, to deal with the hypothetical example that was put yesterday, my lord, I would say this is relevant because it's if what you are responding to are the consequences of what somebody wants to do in manifestation of religion or belief, that is not direct discrimination if you would have done exactly the same thing, if those consequences would have arisen with somebody who is of a different religion or belief. So in the case of the charity, you would say, well, I'm frankly not interested in the fact that you're a Christian and that's what has made you say these things. The consequences for me as a charity are that I can't work with my client base when you express views like that. I'm indifferent to whether you're Christian, whether those views are expressed because you're a Christian or because of some other background. What I care about are the consequences of the message. And so here, if one thinks about what this case is about, an important ingredient in the decision of the respondent is about the consequences of what Mr. Page says. They're consequences which frankly could have arisen if the message that he had communicated had been communicated by somebody who wasn't a Christian. And it's not hypothetical to say that there are others who are not Christians who might well share a view about sinfulness of homosexuality and about the desirability of children being adopted by heterosexual couples that might be thought applied equally to some members of the Muslim community, for instance, or the example that my Lord Justice Peter Jackson gave today of an Orthodox Jew. It doesn't...
Or not, people might have that view for no religious reason at all.
For no religious reason at all.
It's not so much comparing religion to religion, is it? It's more instructive to compare religion with non-religious, secular.
And it may be the point I'm seeking to make is simply it's not direct discrimination if your concern, if the reason why you do what you do is because of your concern about the consequences of the action. In the ASME case, it happened to be the consequences of the desire to wear the face veil, which was accepted, seems to have been common ground as a manifestation of religion. If, arguing against myself for a moment, the court were to think here that what Mr. Page had done was a manifestation of religion, I say he still loses on the analysis of the reason why, because the reason why the respondent does what it does is not because Mr. Page is a Christian or because Mr. Page has a philosophical belief in who should adopt children. It is about the consequences of the message, and that could be a message that is communicated by people from a whole range of backgrounds. That I always hesitate to say this, that the problem is the message, not the messenger. And for a direct discrimination case, your problem has to be the messenger. and the religious views of the messenger.
Okay.
So what we have in this case is, if one looks at the reason why, then the issue of an appropriate comparator falls into place. My Lord, you said as much in the case of Choudhury, which you have in the authorities bundle before you, which is at tab 31. No, forgive me, tab 10.
Tab?
10. Paragraph 31 in my speaking there. The facts bear some similarity to the Wasney case. But at paragraph 23, then, my Lord, you deal with, probably one should pick it up to start off with from paragraph 21 at page 176, because otherwise what you say at 23 doesn't
Well,
make
in that case, would it, again, be quicker if we just read through this?
Yes, 21, 22 and 23, my Lord.
Yes.
Yep. So that is, you set out there how one addresses the reason why. One should focus on the reason why, and once you carry out the reason why analysis, then that enables you to work out who the comparator ought to be. And the difficulty, and I think this is an unsurmountable difficulty for Mr. Diamond, is that the tribunal found against the claimant on the facts of this.
Say it again, sorry.
The tribunal found that against the claimant on the facts in this case. They found that the reason why was something other than the manifestation of religion. And there is no perversity challenge to the findings of fact of the Employment Tribunal. And accept that, put it this way, that the judgment could be more tidily expressed than it is. But it is, in my submission, plain that the tribunal find as a fact that the reasons the respondent give for the reasons for the decision they take are genuinely those reasons. That it's not an artifice or a sham.
Which reasons? I mean, the reasons stated in the letter.
Stated in the letter and then replicated 11.42, 11.43. They find as a fact that those are the respondent's reasons.
Yes, and it's clear that those were amplified, I don't think added to, but amplified in oral evidence by both Ms. Scanlon, who wrote the report, and Ms. Thompson, who chaired. Was it Thompson who chaired the?
Yes, who chaired the TAP.
Yes, but we haven't got a note of their oral evidence, but it was no doubt reflected in the findings.
Yes.
Yep.
And we looked yesterday at what paragraphs 11.42 and 11.43 say, but one might say, sort of very broadly speaking, 11.42 deals with the issue of expressing views that could be seen as homophobic, and then the issues that we've ventilated today about staff concerns and the confidence of the LGBT community. And then at 11.43, there's the point that my lady Justice Simler raised this morning about not distinguishing between the personal and the public, the active engagement with the media, and then finally, almost for good measure, he'd been told not to do it. I reflected, my Lord, overnight on what you said about the manner of expressing beliefs, that using that particular phraseology might be said to be an unnecessary distraction in this case. Because, of course, what one has to do is actually focus on the reasons that were given and the reasons that were accepted by the Employment Tribunal. And it would seem to me, sort of carrying out that marrying up exercise that I talked about, of marrying up what the tribunal says at 11.42, 11.43, with what it says later on as the EAT refers to. If one looks briefly at paragraph 52, page 317, where they say the respondent is indeed because of the manner in which the claimant expressed his beliefs. It would seem to me that that is picking up on those ingredients in paragraph 11.43. So it's about the not distinguishing between the private and the public, about the active engagement with the media. He wasn't put on the spot, he wasn't doorstepped, and finally they'd been told not to do it. And then, and that is also picked up as well at paragraph 55. The act or acts were accepting invitations to appear, compounded by the fact that he did so without informing the trust, expressing his views in that context, etc. And then at 57, that's where it seems to me that the Employment Tribunal picks up on its findings of fact at 11.42. That is where they make reference to the concerns that had been expressed and about the engagement with the community. And that, I would submit, picks up on the themes that are expressed in 11.42. So although it's not felicitously expressed, I think that one can say that at 52, 55 and 57 one can trace through what is said at 11.42 and 11.43.
Which in turn go back to the letter which
in turn go back to the letter. Mindful we have 2 minutes before the short adjournment, I was going to look very briefly at the Leon Ashes and indissociability case. When I have done that, I will have concluded my remarks on direct discrimination. The court, of course, may prefer to break now, or may prefer me just to deal with that short point.
I think let us break now. Then you've got to deal with indirect discrimination.
Yes.
The justification element.
Yes.
Well, of course, strictly speaking, that doesn't arise on the tribunal's reasoning,
Yes.
but I think you raised it in your respondent's notice,
Yes.
but you've effectively dealt with that.
I have. I think I can say that victimisation will be exceedingly brief.
Well, you'll be matching Mr.
And indirect discrimination, I've dealt with justification, and therefore I'll just need to say something about the approach to group disadvantage.
Yes, no, you will need to say something about
with
that.
Graham Mulberry, which of course is a case with which Lady Justice Simler is exceedingly familiar, having sat on the court.
Well, we've taken much longer than any of us predicted, but that is not your fault. And we will still be comfortably finished this afternoon, even if we call on Ms. Ling, which we will tell her when you've finished.